Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. We would look today at the complex interaction between sanctions and sovereign debt, and we would take Russia as a case study to consider the complexities of the issue. And more specifically, we would follow the following logic of the presentation. We would first of all briefly put this into context of sovereign debt, would briefly discuss how sovereign debt is issued by a sovereign on the example of Russia, what type of investors invest in sovereign debt, what is the infrastructure used to permit such investments, and then we would consider what an efficient sanction program can or cannot do, take into account the need to balance the interests of the investors, which very often can be the nationals or corporations coming from the sanctioning jurisdictions, and the political objectives pursued by the sanctions program. And then we would conclude by some practical considerations of taking Russia as an example and considering what the investors can or cannot do in the current scenarios. Sovereign debt would be typically issued in two forms: so-called international debt, which would be issued on foreign, meaning non-domestic markets of the sovereign. And this type of securities are commonly called Eurobonds, but that's just a way to call debt securities issued in foreign markets and typically in foreign currencies. And then domestic market, where the sovereign will typically issue to its domestic investors. And these, in our case, would be represented by Russian domestic bonds, which are primarily issued in Russian rubles, given that they are oriented towards domestic investors. Important point to remember is that, legally speaking, there is no prohibition for a Russian or Russian origin investor to invest in foreign securities like Eurobonds, subject to opening relevant accounts, which historically has not been an issue, as well as for a foreign investor to invest in Russian domestic securities, again, subject to complying with infrastructural requirements in the relevant jurisdiction. So as a practical matter, although we would say that Eurobonds are targeting foreign markets and foreign investors, and Russian domestic securities are more focused on domestic markets and domestic investors, there is a substantial mix of both categories of investors investing in both categories of securities. Taking a closer look at Russian Eurobonds, first important point to mention is that Russia has a long history of borrowing from foreign markets with its ups and downs, ups in terms of various financial innovation techniques, which the Imperial Russia deployed as early as the times of Catherine the Great. And then in the 19th century, when substantial amounts were placed with leading London and French financial houses, which then issued smaller denomination securities for those large sovereign loans. So one might say that as early as end of 18th, 19th century, Russia was one of the first nations to invent the securitization of sovereign debt. There were also downs, obviously, in this history of sovereign debt issue to foreign markets. The first default occurred shortly after the October Revolution in 1918, when the new government, in essence, renounced its foreign debt obligations, and that gave a long history of subsequent attempts to recover those debts, which lasted for tens of years. And then two more recent defaults, which occurred in the 90s, following the collapse of the Soviet Union, and then following the speculation in Russian actual domestic bond market in late 90s, where also a substantial number of foreign investors participated. The recent trend following that recent default of late 90s was a quite reserved view of Russia towards utility of foreign debt financing. And we can see that even at its height, Russian Eurobonds were around 30 billion US dollars equivalents, which is frankly insignificant for a top 10 economy like Russia. Nevertheless, even today, there is a substantial number of such debt securities outstanding. We talk approximately around 9 billion Eurobonds, which are held by foreign investors. Obviously, it's difficult to have the exact statistics here, but this roughly gives us the idea that we still talk about a substantial number of both in nominal value and the numbers of investors who are involved in these debt securities. A typical investor profile is interesting to consider. This is likely to be a long-term investor, an asset manager, an insurance company, a family office investing on behalf of the high net wealth individual, long-term, certain part of his wealth. The purpose here is largely to get recourse to a long-term instrument which allows to hedge long-term liabilities of the relevant investors, being life insurance obligations or pension obligations, or just planning long-term wealth of a high net worth individual or family. Structure of a typical Russian Eurobond would be no different from a typical structure of any other sovereign bond or Eurobond issued by another issuer. The issuer would be the Ministry of Finance of the Russian Federation. Securities will be typically governed by English law. They would be issued in foreign currencies, US dollars or euros, whilst each such Eurobond will be typically listed. Standard listing venues are Dublin, Luxembourg, and London. They would not be typically traded on the stock exchanges where they are listed, and this listing is primarily for regulatory purposes, permitting large asset managers and insurance companies to invest into debt obligations, which they often restricted to unless such debt is listed on a recognized stock exchange. But the trades will actually occur OTC through the accounts of the relevant holders or their brokers with the international central securities depositories in Europe, being Euroclear and Clearstream. Another important element, which relevance will discuss in more detail in the course of this presentation, is the presence of National Settlement Depository of Russia in the issuer and servicing of Russian sovereign debt securities. National Settlement Depository being the central depository of Russia. Russian domestic bond market as a structure is larger, substantially larger than Eurobonds market, which is generally consistent with the trend which we've discussed. The focus on domestic sources for borrowing rather than international capital markets. And the structure, again, of a sovereign bond issue would be similar, with the difference that as this is domestic bond issued, it will be typically governed by Russian law and issued in Russian rubles. But an important point to take into consideration is that there is no prohibition to issue, for example, also US dollars or euro-denominated securities to domestic investors. And we will discuss how this has been used in connection with the recent restrictions arising under the sanctions protocol. So having set up the stage for the debt sovereign market of Russia, we would now need to consider a few, at least, matters which a sanction program needs to take into account to achieve its objectives and to minimize any spillover effects to the extent possible. One of them is a question whether you would like to sanction primary market, meaning the market where the relevant issue brings the securities to the market in the first place, or secondary market, meaning the subsequent trade in securities outside of the primary market issue. The trade-off here is quite clear. While sanction in the first segment would clearly hurt the issuer in the first place by restricting its ability to raise new debt in the relevant capital markets. Sanction in the second segment is more problematic because it would, first of all, affect the existing interests of investors, which can very well be from the sanctioned country jurisdiction. Second point to consider is the relevance of infrastructure for the purpose of servicing existing bonds. As sovereign bonds are purchased by a large pool of investors, we talk here about hundreds, maybe even thousands of investors purchasing Russian sovereign bonds. It is quite clear that Russia cannot pay each and every of such investor directly with respect to each coupon or redemptions due to the investor. The infrastructure works in a way that Russia relies on a paying agent and then the chain of depositories, which transmit the relevant bulk payment made by the Ministry of Finance on every coupon or redemption date, all the way through to each and every individual or asset manager or insurance company or bank who bought Russian sovereign bonds. There are certain elements of this infrastructure, like international central security depositories or the common depository, which is the national settlement depository, which are irreplaceable. Meaning that to the extent you sanction any of those persons, this is very likely to affect not just the person itself, but all those payments processed through such persons and all such securities recorded through such persons. So the importance of infrastructure is something which has to be carefully considered in any efficient sanctioning program with a view that you achieve your objectives and you minimize any spillover effects. Third point to consider is the complexity of in-court enforcement of any sovereign debt obligations. Meaning that if for one reason or another you work the existing infrastructure unworkable, and the result of this would be the event of default, then who will bear the negative consequences of such an event of default? If the enforcement proceedings can be easily initiated, and if the event of default risk is clearly allocated to the issuer, most likely this will be an issuer problem. But to the extent the relevant risks are actually taken by the investors and the enforcement proceedings are difficult, lengthy, then the investors will face the pain. To summarize enforcement, one may say that there is nothing more difficult than to enforce a claim against a sovereign for a number of reasons. The first one is a sovereign immunity, both with respect to a certain jurisdiction over the relevant claim, and more importantly, with respect to attaching the assets once you get the award or a judgment in your favor. Both of these points can be opposed on the basis of sovereign immunity, and whilst the first hurdle, meaning assertion of jurisdiction, is generally surmountable in commercial debt claims, like the issue of Eurobonds, for example. It is substantially more complex with respect to the actual execution of any relevant judgment or award. On top of these general issues, there are some special features in the Russian sovereign bonds which are likely to make any enforcement application more complex. One of them are so-called alternative currency provisions, which allow Russia to pay in Russian rubles, despite the original issue currency of the sovereign debt, which certainly Russia can trigger in the case of sanctions which affect its repayment obligation. And then a question arises of when Russia discharges such payment obligation and how investors can actually collect the relevant proceeds. Short prescription periods, following which the investors cannot issue proceedings, as well as the role of national settlement depository, which acts both as a common depository and as a paying agent. And in the common depository for the global note, arguably it is the national settlement depository which holds the legal title and shall be a party or shall commence the proceedings. Last point to consider is that sanctioning sovereign debt, you actually sanction a person who owes you money on a very substantial pool of obligations. So once you do it, you certainly create a very strong incentive for such person to stop repaying you this amount of debt or to use the money owed to you for other purposes. So sanctioning sovereign debt is an area which is most prone to so-called counter-sanctions measures from the sanctioned state, as it creates enormous leverage over its creditors. And we would see later on how all these issues played out in practice. We would consider now briefly the sanctioning programs of key jurisdictions in the US, the European Union, and the UK with respect to Russian sovereign debt. Start with the US as the most important financial system, capital markets, and obviously the most in-depth and elaborated economic sanctions national program. But the first sanctions against sovereign debt were introduced as early as 2019. And we can see that the focus of that sanctions was primarily on the primary market and prohibition for the US banks to act for Russian Eurobonds, which would be typically issued in non-Russian rubles. As mandated lead arrangers or global coordinators, it did not prohibit the US financial institutions to act in the secondary market, meaning to facilitate the transactions whereby the US asset managers, insurance companies, or other investors would like to purchase Russian sovereign debt. And by doing so, certainly that was a sanction primarily aimed at such institutions and maybe the ability of Russian Federation to access, in the course of primary issuers, the relevant investors in the United States. Nevertheless, one can say that it was certainly of limited application and adversely affected both the financial institutions acting in this area as well as the issuer. These sanctions were added subsequently, the prohibitions for the, again, US financial institutions only to act in the primary market, now also for Russian ruble denominated securities, which, as we've discussed, are largely Russian domestic bonds, where I doubt any big US financial bank acted as a mandated lead arranger or global coordinator in the first place. So we can say that this prohibition added nothing in practical terms. The second one, though, is more important because it restricted also the secondary market transactions. In essence, cutting off the access to new issuers of Russian sovereign debt to the majority of the US investors. Because although the prohibition was directed to the US banks and not, for example, to a US individual who would like to who would like to purchase a Russian sovereign bond, certainly most of the US individuals will acquire those bonds through the facilitation of the US securities brokers. And certainly, as far as those brokers cannot facilitate any of those transactions, there's de facto cut off from new issuers the ability to sell those securities to the US investors. Nevertheless, following 2022, a substantially more restrictive measures were put in place, which bring the level of sanctions applicable to the Russian sovereign debt in the US to a different level. The most important of those are Directive number 4, so-called Russia Sovereign Transactions Directive, where the United States prohibited any transaction, and the term transaction is given its natural, so very broad meaning, with Russian sovereign institutions, including the National Wealth Fund, Central Bank of Russia, and the Ministry of Finance of the Russian Federation, which, as we discussed, is the issue of Russian sovereign debt. So that's a very broad prohibition, which, as OFAC clarified, excludes in substance only divestments of Russian sovereign bonds. Another important and another very broad prohibition was issued pursuant to a number of executive orders, where the most relevant and the broadest would be Executive Order 14071, which prohibited the US persons. And here we talk about any US person, so not just a bank, but also an individual of US nationality living in the US or abroad, any person, any US company, any branch of the US company, any alien living in the United States, to make new investments in the Russian Federation. And new investments would arguably cover any purchase transaction. In the UK, the sanctions are also in place against Russian sovereign debt. And in essence, they prohibit any primary market transactions after 1st March 2022, because any dealing with the transferable security is no longer permitted. And the secondary market transactions are applicable only with respect to such new issues. So the existing market shall be largely grandfathered. Same approach is followed in the EU, where the relevant rule is found in Article 5A of Regulation 833, which sets the 9th of March 2022 as the relevant cutoff date for both primary and secondary market operations with Russian sovereign debt securities. So applying those rules to the economic realities of trading Russian debt, what a typical foreign investor with a position on Russian sovereign debt securities can still do as of today? Well, primary issues are prohibited and no participation is permitted, and this would be logical given the overall focus of the finance sanctions to cut off Russia from new issues of debt or equity in the Western jurisdictions. Nevertheless, as we saw, also secondary trading in certain jurisdictions, US would be the first example, is substantially restricted, given the prohibition to engage in any transactions with the Russian sovereign entities, including the Ministry of Finance. Originally, a general license was in place to wind down relevant positions, but no longer there. So as of today, it would appear that to the extent there is a US investor with participation in the Russian sovereign bonds, then such investor is only permitted to divest of the relevant positions. Nevertheless, and here we come to the second layer of our analysis, even the divestment transaction will not be that easy to accomplish, because to sell a security, you need to buy somebody who can buy the security. And although in some jurisdictions, like European Union, for example, the purchase of grandfathered securities remains permitted, due to the blocking sanctions imposed in all three jurisdictions against the National Settlement Depository, which acts as a paying agent on the Russian sovereign bonds, meaning that any payment, whether of coupon or of redemption at maturity, is processed through such depository. There are no possibilities, in essence, to continue making payments and redemptions of those bonds, and then a question arises of who will purchase the bonds which cannot be serviced in accordance with their contractual terms. Another layer of complications which are applicable and which we discussed are the counter sanctions taken by the Russian Federation with respect to its sovereign debt, where in essence, one of the measures was that the repayments are instructed from the frozen funds of National Settlement Depository held on its accounts with the EU International Central Securities Depositories, the Euroclear and Clearstream. Namely, as National Settlement Depository acted as a gateway between Russian investors and non-Russian issuers, it services most of the payments made on those securities in which Russian individuals invested. As National Settlement Depository is now blocked, subject to asset freeze, these relevant assets are frozen. Technically, as the assets are frozen of the accounts of National Settlement Depository, to the extent the National Settlement Depository now has to make a payment on behalf of the Ministry of Finance with respect to Russian sovereign debt, the National Settlement Depository says, well, please take a part of those frozen money and make the repayment. So the counter sanctions, whereas we would use the relevant funds to repay those individuals who invested in the foreign securities. So we can see how the layer of countermeasures introduced by Russia create another set of obstacles in terms of getting the repayments. So all in all, the solutions are complex, would require a careful consideration of the laws of various jurisdictions, as well as those countermeasures which are taken by the Russian Federation. So to summarize, we can very well see that in a modern, interdependent, complex world, sanctioning sovereign debt is a very complex matter. It certainly hurts the relevant issuer, but there are very important spillover effects also on the investors from sanctioning jurisdictions. I trust that you found this presentation useful, and thank you very much for watching.